This is a lecture for professional responsibility. We're going to be talking about Model Rule 1.4, which deals with the duty to communicate with your client. And what a couple things that just as a preview, I'm going to go through the rule. And instead of doing a separate video where I go through all the comments, I'm just going to hit the comments that matter the most for testing purposes or clarifying the rule in this video. The other thing I want to point out to law students is that there are two rules that actually generate most of the grievances or complaints to against lawyers by clients to the state bar, at least in Texas, and that's this rule and what the model rule is called the duty of diligence. Some states call it you expressing the negative with neglect of a client matter. And so in terms of what you, and most of the disciplinary actions are about these two rules. It's not to say you can't get in trouble for other rules, but 1.4 does generate a lot of client complaints and a lot of disciplinary actions against the lawyer. So this is actually a rule that will matter a lot for your life when you are in practice. So here we go. 1.4a, a lawyer shall, 1, promptly inform the client of any decision or circumstances with respect to which the client's informed consent, as defined in 1.0e, is required by these rules. And 1.0 is our definition section of the model rules. And so if there's anything a decision that the client has to consent to, don't put off or postpone getting the client's, informing the client about it. 2, reasonably consult with the client about the means by which the client's objectives are to be accomplished. And I have reasonably highlighted here because it doesn't mean you have to call your client every 5 minutes and say, so how does a sentence sound when you're writing a brief or something like that. There's some latitude here for, well, the disciplinary authorities, and also the idea that lawyers should be keeping the clients abreast of what they're doing and why, so the client isn't in the dark about how you're proceeding with the representation. 3, keep the client reasonably informed about the status of the matter. And 4, promptly comply with reasonable requests for information. Again, the ABA recognizes that some clients can be unreasonable in their expectation. Call me every hour for every day of the representation. That's pretty unreasonable. On the other hand, it's not unreasonable to expect to call the lawyer once a week or every 2 weeks and say, so is anything new happening with my case? 5, consult with the client about any relevant limitation on the lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the rules of professional conduct or other law. And so this is significant. I don't think you'll be tested on this provision, but just very quickly, this means that if you if the client wants you to do something that you can't do ethically because of the ethical rules or because it's illegal, don't just not do it or ignore the client's request. You actually have a duty to explain to the client why you're not doing the thing that they asked you to do. B, a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. Now, I have to tell you, some of the disciplinary actions that I see every year, every month actually, about failure to communicate with clients, some are the lawyer just doesn't respond to phone calls for weeks or even months at a time from the client. But also we see cases, disciplinary actions, where the lawyer doesn't really tell their client some critical pieces of information that would have been helpful in making an informed decision about how to proceed in the representation. And so you have to, it is part of your job to take the time to explain things. If you're an impatient person, and I think a lot of lawyers are, it can get really frustrating to try to explain things to a client who's not a lawyer and doesn't really understand. And you kind of have to pack your patience a little bit and take the time to explain it. You may have to explain things repeatedly on different occasions because they didn't really understand the first time, and so forth. Okay, now, hitting a few of our comments here. Comment 2 um, uh, it actually adds some provisions that the MPRE considers testable as if it were part of the rule. If these rules require that a particular decision about the representation made by the client, paragraph A1 requires that the lawyer promptly consult with and secure the client's consent prior to taking action, unless prior discussions with the client have resolved what action the client wants the lawyer to take. And so if you've already settled something with the client about what to do in a certain situation, that's okay. But otherwise, if the client has to consent, don't delay in informing them. When a client makes a reasonable request for information, A4 requires a prompt compliance with this request. Or if a prompt request is not feasible, that the lawyer or a member of the lawyer's staff acknowledge receipt of the request and advise the client when a response may be expected. And a lawyer should promptly respond to or acknowledge client communications. And I got to say something about this. So when I practiced law, my first job was at a legal aid clinic, and I would do Social Security disability cases for about a year and a half or 2 years. And you would get one of these cases, the client would file their request for a hearing, and I would have to explain to the client, nothing is going to happen on your case after our initial consultation for probably 6 months at least, right? That's how big the backlog was on the docket at the time. And so if a client calls you and you've said there's not going to be any news, no developments in this matter for 6 months, it can get kind of frustrating that they're calling every week saying, what's happening to my case? What's happening to my case? And I try to tell my students, try to empathize with your client. You have a whole bunch of cases you're juggling and you're really busy, but if they may very well have only your case and they're at home kind of pacing around, wringing their hands like, what's going on with my case? Why hasn't my lawyer called me? And so forth. So there's no reason from the model rule standpoint that you can't at least have your support staff, like a receptionist or secretary, call the client and say, the attorney says there's no new news, right? He got your message and he will call you when there's a development, but for right now, there's nothing to report because we're still just waiting for a response or something like that. And so it really helps. And in practice, this will save you a lot of trouble with unhappy clients who file complaints. Comment 5. The client should have sufficient information to participate intelligently in the decisions concerning the objectives of the representation and the means by which they are to be pursued, to the extent that the client is willing and able to do so. And adequacy of communication depends in part on the kind of advice or assistance that is involved. And so if you're wondering, like, how much do you have to communicate and explain to your client, it's enough for them to participate intelligently in the decision. Again, there are lawyers who develop this bad habit of just thinking that they know best, and they kind of make the decisions and tell the client afterwards. And that's really not what you're supposed to be doing. In litigation, a lawyer should, here's a clarification. I really like this comment, by the way, and because I think it makes it really clear what we're talking about. In litigation, you should explain the general strategy and prospects for success, and ordinarily should consult the client on tactics that are likely to result in significant expense or to injure or coerce others. So you can explain something like, so what we're going to do is we're going to raise a defense, or we're basically arguing this case on procedural grounds. They don't have to understand all of it the way a lawyer would, but you should explain that we're trying to avoid dealing with this issue and focus on procedure, or the other side is focused on procedure and we are arguing about fundamental fairness or something like that. That's a general strategy. And it is very important that you try to give the client a realistic sense of the likelihood of success. You're not going to win every case, and it's okay to bring cases that are a long shot. And when you bring a long shot case, that means you're probably going to lose, right? And so go ahead and tell the client that. Now, I want to say something, just talking for a moment about the costs and the injury to others. If the if you're going to do something that's going to run up the tab quite a bit, like hiring experts, that right, very, very, very expensive, hiring jury consultants, getting more and more like second, third, fourth medical opinions, and so forth, the client is paying for that, and they have a right to be involved in that decision. And nobody likes it when their lawyer um, goes out and goes on a spending spree with experts and stuff like that without checking with them about whether it's worth it to them at that point. Similarly, if you know that if you can see that going to the next stage of litigation is going to involve a lot more expense for the client, um, you have to explain that to the client. Like, look, we're still at the pleading stage. If we get into discovery, it's going to get really expensive. Okay, last, let's talk about injuring and harming others. So sometimes a client has an idea, they want to be vindicated, they want to be compensated or something like that, and you have to explain that there can be consequences that will affect other people. So do they really want to, for example, humiliate one of their family members or a coworker or a close friend? There can be implications, for example, with another party's with custody of children, right? So you have to explain things to the client, like, you can do this, but I hope you recognize that it's going to have implications either for your kids or for this other person's kids. You could do something that has implications for the other person's employment or immigration status or something like that. And sometimes clients aren't really aware that, like, they're out to get compensated, and maybe it's a principle of the thing and they want an apology, but you have to ask them, do you really want to, like, ruin this person's life, or do you really want this person to be deported or to lose custody of their kids or something like that? Think about it. This can have far-reaching consequences. Okay, let's go back to the last couple of comments. On the other hand, you will not be expected to describe trial or negotiation strategy in detail. The guiding principle is that the lawyer should fulfill reasonable client expectations for information consistent with the duty to act in the client's best interest and the client's overall requirements to the character of the representation. So you don't have to tell them, and then when this guy objects, I'm going to say, but this, or when he presents evidence, I'm going to say, objection, Your Honor. You don't have to turn to your client constantly at trial, for example, and say, is it okay if I make an objection? Or this is what we're going to do. Or this is what I'm thinking about jury select, why I want that juror and not this one. You don't have to tell your client everything. Now, keep in mind, if your client is a lawyer, for example, is in-house counsel at a corporation and they've outsourced litigation to you, they actually may want to micromanage you a little bit more, and that's okay. They're the client. Comment 7, I know we're skipping comment 6. A lawyer may not withhold information to serve the lawyer's own interests or convenience or the interests or convenience of another person. Rules or court orders governing litigation that provide the information supplied to a lawyer may not be disclosed to the client. I'm going to say this again and again throughout the course, my professional responsibility course. If a court orders you to do something, you are generally protected from a disciplinary standpoint, from an ethical standpoint. And so now you can object to what the court's doing. The court may be wrong, and so forth. But I really don't think you're going to be disciplined by a state bar, for doing something when you were ordered by a tribunal to do it, right? Comply. The client may be mad at you, the client may fire you, and so forth. But for testing purposes, a good rule of thumb is you almost always can just go ahead. You're covered if you're complying with a court order. And Rule 3.4c directs compliance to such rules and orders. Now, I want to say one more thing about the lawyer's convenience here, and that is one of the reasons that lawyers don't communicate with the client is that they have it's inconvenient. And so either you're too busy and the days suddenly slip into weeks and you've lost track of how long. Now it's been weeks since you've told the client about something. but also it could be, and this is going to come up later, that you have bad news to the client, and you have a client who has a volcanic temper and you hate getting screamed at, and they're going to swear at you and things like that. Or this is a client who's kind of fragile, and they start crying uncontrollably when you give them bad news on the phone. And as a lawyer, it's easy to put that off and to say, oh, I'll call them tomorrow morning first thing. And then you get in the next morning and you're like, oh, I'll just do some emails before I make that unpleasant phone call to the client. And then it's like, well, I'll call them after lunch. And before you know it, that day's gone by, and then that week has gone by, and so forth. So when you have a client who's difficult, and the world is full of difficult people, it can be a matter, the real reason you're not communicating is because of you, right? Because it's a headache for you, or emotionally draining for you, and that's not a good reason, and it spells it out right there in the model rules. Okay, so that concludes our lecture about 1.4.